are now on falsification. There are 4 documents which may be the subject of falsification. We have public document, official document, commercial document, and private document. A public document is one prepared and executed by a notary public or a competent public officer with the solemnities required by law. An official document is one issued by a public official in the exercise of his official functions. A commercial document is a document defined and regulated by the Code of Commerce or any other mercantile or commercial law. And a private document is any deed or instrument executed by a private individual without the intervention of a notary public or any competent public officer, by which document any disposition or agreement is proved, evidence, or set forth. These are the 4 kinds of documents which may be the subject of falsification. It is necessary to know the kind of document that has been falsified, because if the document falsified is a public, official, or commercial document, there is no need to prove damage or intent to cause damage on the part of the offender in order to convict one of falsification. But if the document falsified is a private document, for the crime to arise, it is necessary that damage was caused on the offended party, or at least the intention of the offender is to cause damage. Without damage, there is no falsification of private document. Article 171 punishes falsification committed by a public officer, employee, or notary public, and even an ecclesiastical minister. The following are the elements of falsification under Article 171. First, the offender is a public officer, employee, or notary public. He can also be an ecclesiastical minister. Second, that the offender takes advantage of his official position. Third, that the offender falsifies a document through any of the following acts of falsification. First, by counterfeiting or imitating any handwriting, signature, or rubric. Or second, by causing it to appear that persons have participated in an act or proceedings when they did not in fact so participate. Or by attributing to persons who have participated in an act or proceedings statements other than those in fact made by them. Or by making untruthful statements in a narration of facts, or by altering true dates, or by making an alteration or intercalation in a genuine document that changes its meaning, or by issuing in an authenticated form a document purporting to be a copy of an original document when no such original exists, or by including in such copy a statement contrary to or different from that of the genuine original. And lastly, by intercalating any instrument or note relative to the issuance thereof in any protocol, registry, or official records. If the offender is an ecclesiastical minister, it is necessary that the document he falsifies must affect the civil status of a person. These are the elements of falsification under Article 171. The offender can either be a public officer, employee, or notary public. If it is an ecclesiastical minister, for him to be liable under Article 171, it is necessary that the document that he falsifies must affect the civil status of a person. The priest falsifies the birth certificate of the birth certificate of X. Is the priest liable under Article 171? The priest is not liable under Article 171. The birth certificate will not. It will not affect the civil status of a person. But what if the priest falsifies the marriage certificate of X? The said priest will be liable under Article 171. In the first problem, what shall be the liability of the priest? Still falsification, but not under Article 171. It shall be under Article 172. The second element requires that the offender takes advantage of his official position. The offender is said to have taken advantage of his position if he has the duty to prepare or otherwise intervene in the preparation of the document that he falsifies, or if he is the one in custody of the document that he falsifies. There is abuse of his public position in the commission of the crime. And what kind of document is falsified under Article 171? Although Article 171 did not specifically specify the kind of document that is falsified, the fact that the offender is a public officer, employee, or notary public, it necessarily follows that the document falsified is a public, official, commercial document. Under Article 172, the law punishes three acts. First, falsification of a public, official, or commercial document by a private individual. Second, falsification of a private document by any person. And the other one is use of falsified document. In case of falsification of an official, commercial, or of a public, official, or commercial document by a private individual, here, the offender commits any of the acts of falsification under Article 171. So those acts of falsification enumerated under Article 171 would also apply in Article 172. The second element requires that the document falsified is public, official, or commercial. And last element, the offender is any person. The offender is a private individual. The second act punished under Article 172 is falsification of a private document. Here, the document falsified is a private document. The offender commits any of the acts of falsification enumerated in Article 171 except paragraph 7. Because paragraph 7, act of falsification, can only be done or committed by a public officer or employee, not in a private document. And the last element of falsification of private document requires there must be damage caused to the offended party, or at least the intent of the offender is to cause damage. The third act punished under Article 172 is use of falsified document. If the falsified document is used in a judicial proceeding, there is no requisite to prove damage. But if the said falsified document is used in any other official transaction, for the crime to arise, there must be proof of damage or at least intent to cause damage. Attorney X, the counsel for the defense, who lost the case, filed a motion for reconsideration. The court decided the case, promulgated the judgment on June 30. And the same was received by the counsel June 30. He filed the case before the court, the motion for reconsideration. He filed the motion for reconsideration before the court, gave it to the said receiving clerk. The clerk stamped receipt, and it was only then that Attorney X realized his MR was filed out of time because the date stated there was July 16. He has only up to July 15 to file the motion for reconsideration. And so, he called on the clerk of court, who happened to be a close friend. And he told the clerk of court, paano yan pare na out of time ako? And so, what the clerk of court did, walang problema. So he stamped again and antedated it. This time, it is July 15. Hence, the motion for reconsideration is now filed on time. But it was discovered by the opposing counsel. What case may be filed against the counsel of the defense who filed the motion against the clerk of court who antedated the said date of receipt. The clerk of court can be held liable for falsification. He can be held liable for falsification of public document once it is received. It is already a public document. And what act of falsification? That is by altering 2 days. The first date of receipt was July 16. Yet he altered it. And in doing so, it changed the meaning of document. July 16, it was filed out of time. It is a mere scrap of paper. July 15 now. It is a valid motion for reconsideration which may be considered by the court. Hence, the clerk of court is liable for falsification under the 5th Act by altering 2 days. The son wanted to sell the property of his father. His father, however, was already deceased. And so what the son did, he asked the said notary public to prepare a deed of absolute sale, transferring the property to him, as if the father sold the property to him. And the son affixed his signature as the buyer, and then he imitated the signature of his deceased father as the seller, right in front of the notary public with the consent of the notary public. And thereafter, the same document was notarized. What crime or crimes had been committed by the said son and by the notary public? In so far as the notary public is concerned, he is liable for falsification of public document. Under what act? He is liable under the 2nd Act. He caused it to appear that the deceased father participated in the said sale of property, when in fact, he could not have do so because he is already dead. He caused it to appear because he allowed the son to affix a signature to that of the father. How about the son? The son is liable for falsification of public document under Article 172. Falsification of public document by a private individual. And what act of falsification? Under the 1st Act. He counterfeited, he imitated the signature of his father. There is an original signature of his father, and he imitated and counterfeited the said signature of the father. Therefore, he is liable under the 1st Act of falsification, under Article 172, falsification of a public document by a private individual. What if X was applying for a job in the government? He saw an opening and he was applying for a job. Let's say he was a lawyer, he was applying for a job in the government. And when you apply for a job in the government, you have these clearances. There must be clearance from the DOJ to certify that you are not involved in any criminal case. Clearance from the Office of the Ombudsman to show that you have not been charged of any crime. And so, X completed all the requirements, the clearances, the application, the clearances, as well as the recommendation. And then he submitted the same to the said department on whom he was applying for the job. When the reviewing committee of the said department looked into the application of Attorney X, they discovered that his submitted certificate coming from, clearance certificate coming from the Office of the Ombudsman was a falsified one. The letterhead was falsified. The signature of Ombudsman Morales was also falsified. That is not her signature. And so because of this, the head of the department, the head of the committee, filed a case of use of falsified document against Attorney X. Is the charge correct? The charge is wrong. What is the proper charge? The proper charge is falsification of public document. Why falsification of public document? Because he who is in possession of a falsified document is deemed by law to be the falsifier of the said document. Since Attorney X was in possession, and in fact he submitted this falsified document, the law presumes he is the one who falsified the said document. Therefore, the appropriate charge is not use of falsified document, but falsification of public document. But what if Attorney X was indeed charged of falsification of public document? During trial on the merits, however, it was discovered he was not the one who falsified the document. It was another person, it was given to him, he simply used it in his application. Can the judge convict him of use of falsified document in an information that charges him of falsification of public document? The judge cannot. Because both crimes are separate and distinct. They have different elements. Therefore, the judge has to acquit him of the crime of falsification of public document because evidence proved he is not the one who falsified it. Upon his acquittal in falsification, can the said state still prosecute him for use of falsified document under Article 172? The state can still prosecute him for use of falsified document. Supreme Court said double jeopardy does not set in because the two have separate elements. So in that case, in case of acquittal upon proof that he is not the one who falsified the document, he can still be prosecuted for use of falsified document. The Supreme Court said that in this case, the appropriate and the proper case would first be falsification, not use, because since he is the one in possession, he is deemed to be the falsifier. Under Article 173, which is read it is falsifying wireless, fictitious and wireless telegrams. And then under Article 174 and 175, the law punishes the persons who issued false certificates. Under Article 174, the law punishes any physician or surgeon who issues false medical certificate in connection with the practice of his profession. Likewise punishes any public officer who shall issue a false certificate of merit, certificate of good service, good conduct, etc. Likewise punishes a private individual who shall make this false medical certificate or certificate of merit. Article 175 punishes not the person who makes this false certificate, but the person who, in possession of this false certificate, and despite knowledge that it is a false certificate, would thereafter use it. He becomes liable under Article 175. X was arrested outside the premises of NBI along Taft Avenue. X was arrested by the police officers because he was caught in the act of selling fake or falsified residence certificate or community tax certificates. These were falsified forms of residence certificate or community tax certificate. He was selling it to all people who are applying for NBI clearance, saying that it is one of the requirements that he must have a residence certificate. Yet when the police look into it, they are fake forms of residence certificate. And so he was charged of falsification of public document. Is the charge correct? The charge is wrong. These falsified or fake forms of residence certificate or community tax certificate are not yet public documents. They are not yet document in the legal sense of the word. They are mere forms. They cannot be evidence of the facts stated therein because there are yet no facts stated therein. No name, no address, nothing. Hence, he cannot be held liable for the crime of falsification of public document. What is the appropriate charge? The appropriate charge is violation of Article 176, possession of instruments or implements for falsification. X was in possession of these fake forms, which are instruments, implements for the act of falsification. Hence, he should be charged and be held liable under Article 176. Under Article 177, the law punishes two acts. We have usurpation of public authority, and the other one is usurpation of official function. Usurpation of public authority is committed by any person who shall knowingly and willfully represents himself to be an officer, agent, or representative of any department or agency of the Philippine government or of a foreign government. On the other hand, usurpation of official function is committed by any person who shall perform an act pertaining to a person in authority or a public officer under false pretense of official position and without being lawfully entitled to do so. In case of usurpation of public authority, the mere act of knowingly representing oneself to be an officer, agent, or representative of a foreign government or of the Philippine government will already give rise to the crime. No need to perform an act. Mere false representation will suffice. But in case of usurpation of official function, the offender performs an act pertaining to a public officer, pertaining to a person in authority, under pretense of official function, and he is not lawfully entitled to do so. X and Y went to the mayor of the place for a civil wedding. They submitted all the requirements, and the mayor told them to come back Friday next week for the said wedding ceremony. And so Friday next week, X and Y went to the said mayor's office for their wedding. Aside from the bride and the groom, there were the ninongs, the relatives, and other guests. They were all in dress. But the executive assistant of the mayor informed them, the mayor is out. The mayor is busy campaigning and will be arriving between 9 to 10 in the evening. But the executive assistant told X and Y, no worry. I am authorized to solemnize your marriage. Come inside the office. And so the executive assistant solemnized the said marriage, the said wedding ceremony between X and Y. Thereafter, he asked X and Y to sign in the marriage certificate on the spaces for spouses, the ninongs and the ninangs as well. And then the executive assistant told X and Y, you come back tomorrow. I will give you the copy of the marriage certificate tomorrow, signed by the judge already. And so, X and Y left. The following day, they went back to the office, and true enough, the executive assistant gave them a copy of their marriage certificate. There was already the signature of the judge as the solemnizing officer. What crime or crimes had been committed by the executive assistant as well as the said mayor? Insofar as the executive assistant is concerned, he is first liable for usurpation of official function. He does not have the power to solemnize the marriage, yet he performed an act pertaining to a person in authority under false pretense of official position and without being lawfully entitled to do so. So he's liable under Article 177. He is also liable for falsification of public document because he caused it to appear that the said mayor participated in the said wedding ceremony as the solemnizing officer, when in fact the mayor was out and did not celebrate the said marriage. So he would be liable of the crimes. How about the judge? How about the mayor? What is the criminal liability of the mayor? The mayor will be liable also of falsification. He is liable of falsification by making untruthful statements in a narration of facts. When he is signed therein as the solemnizing officer, he is saying that he is the one who solemnizes said marriage. That is not true. That is making a statement which are untrue. Therefore, he becomes liable also for falsification of public document. Under Article 178, the law punishes two acts. we have using a fictitious name, and the other one is concealing true name. Using a fictitious name is committed when the following elements are present. First, that the offender uses a name other than his real name. Second, that he uses this name publicly. Third, the purpose of the offender is to conceal a crime, to evade the execution of a judgment, or to cause damage to public interest. The other act punished under Article 178 is concealing true name. The elements of concealing true name are that the offender conceals his name and other personal circumstances. And second, the purpose of the offender is to conceal his real identity. In case of using a fictitious name, there is the element of publicity. The use of a name other than his real name must be done publicly. In case of concealing true name, there is no element of publicity. There is no requisite that the concealment of one's identity be done publicly. Both crimes also differ insofar as their purposes is concerned. Related to Article 178 is, na-discuss na sa inyo yung CA 142. So what if Attorney X went to a Sonabat parlor at the exact time that he was receiving massage from a woman working in the said parlor, the police arrived. The police are armed with a search warrant. They were able to get a search warrant because, based on their surveillance, they discovered, although on the outside it is a massage parlor, in the inside, it is indeed a prostitution den. So, by virtue of the said search warrant, we searched the place and arrested everybody there, including Attorney X. When Attorney X was brought to the PNP station for investigation, he was so ashamed to divulge his name. And so, instead of saying Attorney X, he said that he is wild. And when he was asked what is his job, he is ashamed to say that he is a lawyer. And so, he didn't say anything. But when he was asked about his wife, he stated the true name of his wife. He stated the true names of their children. He stated his real address. Thereafter, after the said investigation, he was allowed to leave the PNP station. Is Attorney X liable for using a fictitious name? Is Attorney X liable for concealing true name? Is Attorney X liable under CA 142 as amended? Attorney X is not liable for using a fictitious name. Although he used a name other than his real name, he used the name Y publicly, his intention was not to conceal a crime, to evade execution of a judgment, or to cause damage to public interest. He is also not liable of concealing true name, because although he concealed his real name, he did not conceal his other personal circumstances. Therefore, there is no intention on his part to conceal his real identity. Likewise, he is not liable under CA 142 as amended. He is not liable under CA 142 as amended because, as held by the Supreme Court, in the case of Estrada, in the case of Ursula, the use of a different name in a single transaction without any showing that henceforth he wanted to be known by such name is not within the prohibition of CA 142 as amended. Such use of the name Y in the single transaction during the investigation does not make the name Y an alias of Attorney X because there is no element of habituality. He used it only once. He did not use it in any other further transaction. Therefore, in other words, Attorney X is not liable of any crime. But what if Attorney X, when the police raided the place, was found receiving services from a minor. Is he liable of any crime now? He is liable under RA 7610. Attempt to commit child prostitution. This time, he will be liable for child abuse under Section 6 of RA 7610. Under Article 179, illegal use of insignia, uniform, or dress. This is committed by when the offender makes use of an insignia, uniform, or dress. The said insignia, uniform, or dress pertains to an office not held by him or to a class of persons of which he is not a member. And he used the said insignia, uniform, or dress publicly and improperly. For the crime to arise, it is necessary that the insignia, uniform, or dress used by the offender must belong to a class of person or to an office not held by him. Therefore, if the said insignia, uniform, or dress belongs to a simulated office, not a real one, he cannot be criminally liable under Article 179. We go to false testimony. We have false testimony in criminal cases, and we have false testimony in civil cases. False testimony in criminal cases is punished under Articles 180 as well as Article 181. Article 182 punishes false testimony in civil cases. False testimony in criminal cases can either be false testimony against a defendant, and the other one is false testimony favorable to a defendant. Under Article 180, false testimony against a defendant, the following are the elements. First, that there is a criminal proceedings. Second, that the offender testifies falsely against the defendant. Third, that the offender knows that his testimony is false. And last element, that the defendant against whom the false testimony is given is either acquitted or convicted by final judgment. These are the elements of false testimony against a defendant. The elements of false testimony favorable to a defendant are, first, again, that there is a criminal proceedings. Second, that the offender testified falsely, this time in favor of the defendant. Last element, that the said offender knew that his testimony is false. Where lies the difference? In case of false testimony favorable to a defendant, the fourth element in false testimony against a defendant is absent. Under Article 180, before a false witness can be prosecuted for violation of Article 180, false testimony against a defendant, the law requires the defendant against whom he has given the false testimony must first be either acquitted or convicted by final judgment. Such element is absent in case of false testimony favorable to a defendant. In case of false testimony favorable to a defendant, right after the giving of the false testimony, the false witness can already be prosecuted for violation of Article 181. There is no need to wait for the acquittal or the conviction by final judgment of the defendant. The same is true in case of false testimony in civil cases. Here, there is a civil proceeding, and the offender testifies as to the issues relative to the said criminal proceeding. The offender knows his testimony is false, yet he did so with malice and deliberate intent to affect the issues pertinent to the said case. Again, in case of false testimony in civil cases, right after the false witness had given the false testimony, he can already be prosecuted for false testimony under Article 182. The crime immediately arises. Under Article 180, there is the requisite fourth element that before a false witness can be prosecuted under Article 180 for giving a false testimony against a defendant, the defendant must first be acquitted or convicted by final judgment. Reason is, under Article 180, the penalty to be imposed on the false witness is always dependent on the final sentence imposed on the defendant against whom the false testimony is given. Therefore, since the penalty for the false witness depends on the final sentence to be imposed on the defendant, you have to wait for the acquittal or the conviction by final judgment of the said defendant. Otherwise, the case will still be premature. So the accused was charged with the crime of homicide. While the case was ongoing trial, the parents of the victim presented a witness to the fiscal, representing to the fiscal that this witness saw everything. Unknown to the fiscal, this witness, W, was a paid one. And so after interviewing and assessing that he was really present, he can answer all the questions of the fiscal. He seemed to be truthful. And so the fiscal presented the said witness. And the witness testified falsely against the defendant. After trial on the merits, the judge convicted the accused. The accused appealed to the Court of Appeals. While the case was undergoing review by the Court of Appeals, this defendant, this accused ex, was so mad at the false witness, and so he filed a case against him for violation of Article 180. Will the case prosper? The case will not prosper, it is premature. The fourth element is absent. The defendant is not yet acquitted or convicted by final judgment because his case is still on appeal, on review by the appellate court. Therefore, he cannot yet file a case against the false witness. But what if, in the same case, the false witness testified in favor of the defendant? The heirs of the victim were so mad at the said false witness. Can they immediately file the case of false testimony under Article 181? Right after the giving of the false testimony, the heirs of the victim can already file a case of violation of Article 181, that is, false testimony in favor of a defendant. No need to wait for the final judgment insofar as the defendant is concerned. Again, the same is true in false testimony in civil cases.